Good afternoon. Can I deal very briefly indeed, if I may, with grounds 1 and 2?
Yes.
Before moving straight on to ground...
We were reasonably confident that your focus would be on ground 3.
Yeah, I can be very brief indeed on ground 1. You will have seen from the skeleton argument that we do not oppose the GDC's appeal. It's right that it was admitted before the Professional Conduct Committee that Ms Williams' approach to top-up fees was inappropriate, and that's on the basis that was agreed between the experts in their joint statement, a matter we did not feel we could go behind. It's also clear and right that it was no part of our appeal before Mr Justice Richie that the committee had misconstrued the regulations, and indeed you will have seen there was a joint note that I, together with my own friend Ms Harris, put together for the court where we agreed the interpretation. And so on that central issue, we adopt essentially a neutral position on that issue before you today. As to ground 2, I can be similarly brief. We agree with and adopt Mr Vinnell's helpful submission that notwithstanding the joint position below, the judge was entitled to take the approach he did for the reasons Mr Vinnell gives, and I have nothing more to add to that ground.
That was certainly brief.
Can I come on to ground 3 and give you our overarching submission on that? It is clear beyond doubt, of course, that the judge's construction of the contract regulations was material to his findings about dishonesty. It is equally clear, however, that his reasoning did not turn solely upon matters of construction. What the judge found in substance was that however one interprets the regulations, the inference that Ms Williams had acted dishonestly was not justified by the limited evidence before the committee and before the court. In particular, it wasn't justified by the limited evidence as to her knowledge, as to her experience, and therefore as to her level of understanding, the nature of her understanding at the time she charged top-up fees. And therefore our overarching submission, it was plainly open to the judge to come to that conclusion on the evidence before him, particularly in a hearing which it is agreed was an appeal by way of rehearing. My lady, in order to understand why the judge and how the judge came to that conclusion, it's necessary to understand something about the evidence in relation to top-up fees that was given at first instance by Ms Williams. And can I summarise what we say were the core propositions that came out of her evidence? And I'll take you to it and remind you of the main features of it. So the main propositions are, her position was she never did any private work as part of her foundation year training. She was not aware that mixing private and NHS treatment on the same tooth was not permitted at the material time. She accepted in evidence that she had not given conscious thought to whether what she was doing was a breach of the regulations, and accepted that she did not look them up. It was her evidence that she only became aware that what she was doing was wrong when her former supervisor, Dr. Alison Walker, told her that what she was doing was not permissible. And as soon as she was told that, her evidence was she stopped doing it immediately. And can I also make the following submissions about the way in which she was cross-examined about that evidence? It is true to say that during the course of the hearing, Ms Williams was cross-examined about the nature of her understanding and her thought processes. But we would encapsulate it this way. The nature of her cross-examination in my submission was rather like examination in chief. She was asked questions, open questions, designed to elicit her understanding. She was not challenged on the answers that she gave. She was not challenged on the essential propositions that I've outlined a moment ago. It wasn't suggested to her that she was not telling the truth when she said that she didn't know and didn't understand. And perhaps most importantly of all, no basis for disputing her evidence about her state of knowledge was put to her. So it wasn't suggested to her, for example, well, you would have been taught all about this in your foundation year, and this was part of the syllabus, wasn't it? It wasn't put to her, well, actually, Ms. Williams, you would have had practical experience of applying this specific provision, and here's when you would have done it, and here are instances when you did it. Those sorts of questions simply weren't put to her. Can I take you, with that summary, to what we say are the relevant passages in the evidence about that? And you have in the bundle some extracts, certainly not the whole thing, but relevant extracts I've got in by agreement. So if you go, please, to, in the supplemental bundle, to page 120. At the bottom of page 120 at H, you'll see this is my examination in chief of Ms. Williams at the beginning of her evidence. And she was asked, 120, bottom of the page, H, how did the work that you were performing whilst on your foundation year compare to the work you went on to do at Simmons Yacht? Answer, obviously there were similarities, of course, because it was dentistry, but the patient types were entirely different. Whilst I was in that year, the patients I saw had very high dental needs, and they frequently hadn't attended the dentist for a long time, or were irregular attenders. Their attendance could be poor at times. Their needs were very different from those at Simmons Yacht, because the treatment I was doing was often, just to get them stable in terms of their oral hygiene, periodontal condition, treating large amounts of caries, that type of thing. So the opportunity wasn't there to be doing, crowns, dentures, things like that. Although I did do some of that type of treatment, it wasn't, as it then became at Simmons Yacht. They were a different group of patients. Question, did you do, whilst you were on your foundation year, any private work at all? No, it was my understanding that as a DF, and that might be foundation dentist or something like that, you couldn't do private work. And that was not a proposition that was ever challenged in her evidence. If we then go to her cross-examination, which you'll see, it's slightly confusing, it's over the page, but these are extracts. So page 122, we're now on to cross-examination of Ms. Williams. So bottom of the page at H, 122. I wanted to be clear about that. You accept if we were dealing with charges, it was inappropriate because you say that you have now learned you cannot do that, and therefore you accept that telling patient T they could have a ceramic crown by paying an extra fee was inaccurate information. Yes, I know. At the time, I genuinely thought that it was an entirely permissible way to work, and I was just naively thinking I was providing a much better quality material and looking restoration without incurring the very much larger fee for the patient. And then, I'm not going to read it all out, I need to go down to the bottom of page, the same page 123 at F. Can I pause you? Because I'm going to ask you about this, but take it in stages. I just wanted to remind you, if you wanted to be reminded, that you deal with this at paragraph 191 of your statement. You're giving evidence as it happens, but I just want to be fair to you. Answer, I just wanted to say that very, very stupidly, I realise now, I misinterpreted the advice that he gave me as meaning I could legitimately. I think maybe what happened is I was so pleased I'd be able to provide this fabulous crown knife for my NHS patient that I just thought Paul's the supervisor, or the owner of the practice, will be fine about this because I will just pass on that difference in cost to the patient. Obviously, I thought, obviously I would ask if they wanted to proceed that way, and if they did, I could not provide the original NHS option. It was not that I was not offering to provide a crown in any other way, of course. That genuinely is the position, and it was my mistake. I entirely accept now that it was wrong, but I did not realise, and thankfully I did mention it to Alison when I was speaking to. And then can I pause you? I don't want to stop you. If you go on to finish, then I will ask you questions. You mentioned it to Alison. Is that Dr. Walker? Answer, yes, my previous foundation trainer, who I consider to be a good friend. I thought this was a very good idea for my patients. I did not think I was doing anything wrong. I did not see how it could be a problem. Anyway, she advised me it was a problem. So I ceased to do it immediately. I did not do that. I did not ever do that again. Let us take it in stages. You deal with it at para 191. You say you did not understand that it contravened the regulations. Answer, that is correct, yes. But you understand now that it clearly does. Yes, and I'm very sorry that I did it, because I had no idea that was the case. And then over the page to 125, I'm not going to read it out, but to save time, could I just invite the court just to read on page 125 from A to the bottom of the page. I won't read it all out, just invite you to read it. And then just at the top of page 126, in terms of the timing of the advice, because this is referred to in the judgment, top of the page, all right, I think that gives us a flavour of her view of the matter. Can I ask you this? When she gave you that advice shortly after you've been offering this, we can see from the dates of the charge, is it around the June time, I think, of 2018? It was before you left the practice, was it not, that you had this conversation with her? Answer, that is correct. And then just one more extract in relation to her evidence, which is on page 127, bottom of the page H. So the very bottom of the page, question. Do you accept that these are all very basic principles in terms of claiming for NHS dental services? Yes, since all of this has happened, obviously I've undertaken a lot of CPD on understanding the NHS rules and regulations. And now I have a much better understanding of it. So in hindsight, yes, I would say that these were basic things that I should have known, or if I did not know, and there was any confusion about it, I should have sought to clarify sooner than I did. So that's those are the extracts I wanted to take the court to, which give you a flavour of her evidence. The next point is this, that the way in which the committee approached the expert evidence. And you'll recall that, I'm not going to take you to it, but the committee were satisfied from the expert evidence that the non-mixing of NHS and private treatment on the same tooth was, as they put it, a fundamental tenet of NHS regulations. And they went on to say that it is therefore considered, given your knowledge and experience at this time, that it was more likely than not that you were aware of this rule. So the inference is fundamental tenet, infer likely to have known about it. However, the evidence is, certainly the expert evidence from Professor Barker, who was the expert giving evidence on behalf of the defence, was somewhat more nuanced than the committee gave credit for. And in essence, I'll take you to the passages in a moment. Professor Barker's evidence was that on completing a foundation year, a junior dentist would be, quote, still working their way towards an understanding of the regulations, and that the principle about not mixing NHS and private treatment was one of those principles that could give rise to misunderstanding, and did in practice. For those propositions, if I take you back to the transcript, so page 129 of the supplemental bundle, and this is cross-examination of Professor Barker. So 129 is cross-examination of Professor Barker. So 129B, Would you agree that a general dental practitioner would be expected to know that you cannot and should not claim on the NHS and charge privately for the same item of treatment or the same treatment? Answer, again, a similar point, they should, but again, there are clearly instances where that occurs. And then towards the bottom of that page, there were F, again, still in cross-examination. In terms of what is expected of a foundation dentist by the end of their foundation year, they're expected to be familiar with the rules and regulations surrounding NHS claiming. Answer, yes, they should be working their way towards. Certainly they should be understanding the basic tenets, but as I said, there are always elements that you need to go back and revisit. Question, to be fair, they should understand the basic tenets. Answer, yes. Question, but there's always cause to revisit. Answer, we are always learning something new when we read back through. It's amazing how many things you can find in addition. And then we then come to re-examination. This is my re-examination of Professor Barker. And just invite your attention to the bottom of page 130. So I asked Professor Barker, it was also put to you, bottom of very last question, 130, that general dental practitioners should be expected to know that they cannot claim for both NHS and private treatment in the same course of treatment. Pausing there, that's probably a slightly confusing question by me. But in any event, as part of your answer, you said...
Well, to exculpate you,
yes.
There's a slightly more accurate question than the one on page 129 that you showed us before. The second question down. So I don't think even with hindsight you should be too critical of yourself.
I'm grateful for that exculpation, my lord. I will take it. But part of your answer, you said that they should, you said there should, but there were clearly instances where that occurs as part of your answer. That was my note. Can you assist us with what did you mean when you said that? There were clearly instances where that occurs. In respect of question, in relation to claiming for NHS and private costs as part of the same course of treatment. Answer, yes, again, I think there was within a course of treatment, currently you can claim for private and NHS treatment. It cannot be on the same tooth, but you can provide NHS courses of treatment. And again, that brings into account people's misunderstanding of how exactly that works. Then down to E on the same page. You also, in answer to one of my learned friends' questions, said at the end of your vocational year, trainees will be working their way towards an understanding of the regulations. But there are always elements they would need to go back and revisit. I think that was my note of your answer. Can you give us a little more information about that? Why is that the case? Answer again, because there are certain things that you can and cannot claim for. There are certain regulations about free replacements, about the 28-day rule, things like that, again, are not. I have to say, not all general dental practitioners, there's a fair proportion, are not aware of them. So you have to go back and refresh on the rules, because there is a lot of them, and you need to be aware of all of them. You could potentially retrain all of them continually, because there are so many of them. Question, finally, you said generally trainees now have less experience than they previously had at the time they finished their vocational training. Yes. And then moving on, I guess which is the last of my extracts, there were some questions by the committee to Professor Barker, and you'll find those at page 134. Between C and D, Miss Aura, who was one of the panellists, asked this question to Professor Barker. A few questions, please. Would like to ask you a little bit about when dentists come to you in your experience after graduation, newly qualified, start their foundation year. How much understanding do you feel they have at that stage of understanding the rules and regulations in relation to NHS treatment? How much do you think is covered as an undergraduate, really? As an undergraduate, very little, if nil, I think. Certainly most would say they have not covered it, in fact. Inadvertently, I've had a comment from somebody else the other day who said, no, we did not cover it as an undergraduate. Very little indeed as an undergraduate. Question, is it fair to say that when they start their foundation year with any other trainer, that they really have no experience, virtually no formal training, and so during the foundation year and the study days that the foundation year dentists attend, what proportion of those days would you say are devoted to understanding training in NHS claims and regulations? I would say generally they have the day release days, day release courses. I would say during the year they will have one day which they will have specific CPD events, a specific course directed towards understanding the rules and regulations. But then, obviously, because they have several day release days, they have 1 day a week over the course of the year with some breaks in between for holiday periods and the like. So in the other days, there is likely to be some conversation around NHS rules and regulations, but not specifically that is a taught session, which would usually be around 1 day a year, I would say, from experience. Question, that is just 1 day out of their foundation year devoted to the NHS claims and regulations. Answer, that is right, yes. Question, through your experience of working with dentists who are newly qualified, so they have reached the end of their foundation year, do you find through your experience that they can sometimes struggle with understanding the NHS system and making claims in the regulations? And is that being encountered on quite a common basis that people find it difficult to understand? Answer, the ones that have been highlighted, I would say they have a reasonably clear idea, but it is the numbers and the finer nuances that become more of a problem. There will be certain elements, I say the 28-day rule may not have been brought up, or elements like that. It's really depending on how the conversations have gone. I would say in the basic principles of it, yes, they will understand, but in the wider principles and applications, no, there will still be elements they need to be learning as they go along. Question, in terms of learning those principles as they go along, how do you find newly qualified dentists usually gain that experience and gain that knowledge? Answer, during the foundation year, they will have some formal knowledge-based learning that will go on. After that, it would really be dependent upon them finding a continuing professional development event that they would go along to. There will be bits, as we saw in the spotlight, that would highlight things, so they may well get some CPD material through that, but in the main, it will be because of them actually attending a given event, where they would go and find out further, really. They can do it through peer learning as well. Obviously, they can go talk to other colleagues. So there is all manner of learnings. So those are you'll be pleased with that. Those are the end of my extracts. And with that background, can I then go to the judge's reasoning? Because it informs the way in which he dealt with the case. And on the evidence that was before him, we say the judge made a number of findings which were plainly open to him and are certainly not expressly challenged by the GDC in this appeal. And the first place I want to pick up the judgment is at paragraph 68. So page 106 of the bundle, para 68. So the first point he makes is that the arrangements with patients TU and V in respect of top-up fees were all made entirely openly. Openly, they were in the records. There was no suggestion of any deception or cover-up about what was being done. You have that at 68. You also have it specifically in relation to patient T. If you turn to paragraph 85, so the judge says on the 26th of June, the patient returned and the appellant carried out preparatory work on the LR5 crown, provided a composite filling, x-rays were taken, further preparatory work was done. The appellant specifically noted on the clinical record, on the clinical notes, extra lab fee for crown, discussed with patients, she is happy with this. 86, it can be seen from the above clinical note that if the appellant had known or thought that offering and agreeing a top-up fee was in breach of the regulations, or the NHS business term contract terms of the practice, the clinical notes were full and frank confession to that breach. There was no deception in the notes about charging top-up fees. I find this directly relevant to the decision on whether the appellant knew this was dishonest. It seems to me to weigh against such a finding. I shall return to this later because it's also relevant to mitigation. The judge then went on, if you turn to paragraph 95, to identify the specific inferences that the committee must be taken to have made. So you'll see at paragraph 95, halfway down para 95, page 114, the PCC ruled that the ban on mixing private and NHS treatment on the same tooth was a fundamental tenet of the NHS regulations. They appear to have found that all fundamental tenets would have been taught during the foundation year. They appear then to have found that if a tenet had been taught, the appellant would have known it, and so did in fact know. They appear then to have found that if the appellant knew of fundamental tenets when she was taught them, she knew of them when she charged the top-up fees. They appear to have found she knowingly breached the regulations, and that's a perfectly fair, in my submission, unpacking of the inference that the committee made.
But was the change in terminology from basic in the evidence you took us to fundamental significant? I mean, was the word fundamental used elsewhere in the evidence?
I can't recall is the answer to that message. I'm not sure anything really turns on it. I think basic and fundamental mean the same thing. But here, the judge is simply unpacking, as I say, legitimately the inferences that were made. He then, in the course of his judgment, analysed whether the evidence justified those inferences and made a number of points which are in my skeleton argument, but I'll just take you to the relevant bits in the judgment. So at paragraph 99, you'll see, third line down, he made the point that no course notes were provided from the foundation year and that no trainer was called from the foundation year. At paragraph 100, he made the point that it was the undisputed evidence from the appellant that she had completed the doing wholly NHS work and not a mixture of NHS and private work. At paragraph 102, so this is page 117, he makes the point that there was no induction or training at the practice. At paragraph 104, over the page to 118, he makes the point that there was no evidence before the court or the PCC as to the nature of the training given during the foundation year, beyond the fact, of course, that we know it lasted for a single day in terms of the formal training. In the same paragraph, he makes the point that there was no evidence produced that the work the appellant did as a dental nurse or assistant would have provided her with the necessary information about mixed training.
Which is that paragraph, sorry?
It says paragraph 104.
So that's also right.
Yeah, so nor was there any evidence produced that the 10 years of work the appellant did as a dental nurse or assistant would have provided her with the information about mixed funding. That's page 118, paragraph 104. And finally, at paragraph 105, that there was no evidence that she had continued to charge top-up fees after being advised not to do so by her trainer, Alison Walker, in June 2018. So that's 105 on page 119. All of that fed into the judge's overall conclusion at paragraph 106, where he held that there was no direct evidence that the appellant knew that the top-up fees were not permitted. The PCC's finding was therefore a matter of inference. I do not consider that dishonesty was an inference that could be properly drawn on the evidence provided. But the judge goes further than that. It's not merely a matter of evidential insufficiency. The judge went on to find that there was actually some unfairness in making that finding in respect of this particular registrant, for the simple reason that she wasn't cross-examined about the regulations. The regulations weren't put in front of her. The BHSA guidance, the NHS-BSA guidance wasn't before her, and she wasn't cross-examined about her understanding of them. And as to the unfairness point, you'll find that, first of all, at paragraph 97. So, top of page 115, towards the end of paragraph 97, it was not put to the appellant by the respondent in the cross-examination that the dental handbook interpreted the regulations as banning top-up fees, not the regulations or the contract. It was not put that the handbook omits reference to Schedule 3, Para 10. These matters, it seems to me, are fundamental to proof of dishonesty. Then you will see that at paragraph 130, the judge went on to deal with the rule in Brown and Dunn, and there's an exposition from the judge as to what the law says about Brown and Dunn. And then if you go to paragraph 137, you'll see that the judge rejected one ground of challenge based on Brown and Dunn, but not the ground relating to top-up fees. So para 137, for the reasons I set out above, I reject the grounds of appeal based on unfair process involving the allegation that inadequate opportunity was provided to the appellant to defend herself due to inadequate cross-examination, comma, save to the extent that the Dental Council did not cross-examine the appellant on para 10 of Schedule 3 of the Contracts Regulations or the NHS contract with the practice in relation to top-up fees. This should have been done because it was fundamental to the allegation of dishonesty on top-up fees. That failure was serious and relevant to my decision on honesty relating to top-up fees. And whilst we say the judge was correct about that, we say actually the problem was in fact more fundamental than the judge appreciated, because the more fundamental issue is that the registrant was simply not challenged in cross-examination about her understanding of the regulations. It wasn't suggested to her that she wasn't telling the truth. No reasons were put to her for why she might not be telling the truth. It wasn't, as I said earlier, suggested to her that she would have learned and should have learned about it at any earlier stage. And we say that that was fundamental to fairness. And I should say that I make no criticism of my learned friend, Ms Harris. She dealt with the proceedings entirely fairly and properly and scrupulously in her customary style, but presumably it's to be inferred that Ms Harris was cross-examining the registrant on the basis of the material she had available to her, and it's to be inferred that there wasn't really any material that she could put to the registrant to gainsay the account that she was giving. And that leads us then to the ultimate conclusion of the court, which you will see at paragraph 110. So this is page 119. For all the reasons set out above, I consider that the decision of the PCC on the appellant's honesty in relation to voluntary agreed top-up fees were wrong, were procedurally unfair, and were not inferences which could properly be made in relation to patient T. So the wrong is the bit presumably about interpretation of the regulations. Procedurally unfair is the bit about Brown and Dunn, and not inferences which could properly be made is a point about evidential insufficiency. But I've said that the attack on the findings of the PCC go even further than that, and legitimately so, because you'll see, if you look at, just invite to look at paragraph 111. There was to explain, it's not immediately apparent without knowing a bit of the background what paragraph 111 refers to, but during the course of the hearing, the General Dental Council very properly conceded that there was one aspect of the PCC's findings on dishonesty in relation to top-up fees that was simply unsustainable, and that the General Dental Council conceded that the committee had fallen into error. And just to explain that, one of the bases that the committee had for finding that Ms Williams was dishonest was in relation to one of the patients, patient T. It was suggested that it wasn't clear on the evidence that she had ever incurred the laboratory fee that she passed on to the patient. And that was an ancillary...
Was this because she got dismissed before it was completed?
I don't know if they went into that detail. They just said that it was, and I'll take you through it in a moment, that it was unclear that she had in fact incurred this fee, and that was an ancillary basis. To see where we get that from, if you go to the core bundle, so page 68.
So what document is this in?
Sorry, this is in the core bundle. This is in the PCC's findings, core bundle. It's page 68, and it's in the box at the top, which will be 18A. So the committee is dealing here with integrity in relation to patient T. And
sorry, I've just dropped the bundle.
No, that's okay. So on page 68. Just give my leadership a moment. So page 68, it's in the box at the top, which is just so you can see, it's the allegation about integrity in relation to patient T. There's just one sentence, so it's in the box at the top. That's it. Yeah. So further, the committee considered that it was unclear from the evidence exactly what cost was incurred in terms of laboratory fees, which in the committee's view made the £60 charge to the patient T questionable in any event. And then if you go over the page to 69, box at the top, first paragraph, again, last sentence, the committee further took into account Dr. Powell's evidence that it did not appear that you incurred any extra laboratory charge for the Crown, which meant there was no basis on which to charge the patient any additional cost. Now, that's it. So that was an ancillary basis for finding dishonesty. The reason that was challenged on appeal before Mr Justice Richie was A, that basis for finding dishonesty was never put to the registrant. Second, it was never relied upon as a basis for finding dishonesty in the GDC's closing submissions. And thirdly, even on its own findings, on page 68, the committee felt the evidence about this was quote unquote unclear, and therefore applying the usual burden of proof, that was a reason they should have dismissed the allegation. And it's against that background, returning to the judgment at paragraph 111, that you'll see that there's a record that effectively that the GDC conceded that aspect of the committee's reasoning was unsustainable, and it was quashed on that basis.
The judge says he asked them whether they maintained that.
Yes, and I think the position is that they abandoned it. Yeah. There's one final point. It's not a point that's been raised, I think, fairly by Ms Johnson so far, but it may be raised in reply. So I'm going to deal with it on the assumption that it may be raised. It's a point, I'm going to take a notional point against me. It might be said against me that the committee dealt with the registrant's knowledge. And to see where they did that, if you go to page 70, so on page 70, this is patient U. Box at the top. Furthermore, you have submitted that you had limited education. Do you see that? And understanding about the NHS regulations. However, the committee has found in charge 14A that you knew that what was required under the NHS charging system. So that's a finding that was made. That refers back to patient R, and you'll see the charges relating to patient R at page 55 and following. And so it might be said, Ms Johnson might say, well, the committee dealt with education and training. They know best, they heard the evidence, that was sufficient. The serious flaw in that argument, were it to be an argument that was advanced by the GDC, is that the allegations relating to patient R were of a completely different nature. They were nothing to do with top-up fees. They were they were in the context of pure NHS charging. And they were to do with a totally different principle, which was the principle that one shouldn't unnecessarily split up courses of treatment. And just to give you, as it were, the high-level view of what that principle is, the principle is that when a dentist submits a completed course of treatment, they're doing so on the basis that they've completed all the care and treatment that would usually be expected to ensure that a patient is dentally fit. So you do all the treatment that's necessary within one course of treatment. What you can't do, and what is not permitted, is artificially split up a course of treatment into discrete phases to increase the number of UDAs.
Having £5 as 5 courses of treatment.
Yeah, or 2 and 3, and therefore get 24 UDAs instead of 12. That's the principle that allegation was engaging with. And to see that, just so that you can see where that comes from, if you look at page 56 of the core bundle, just to see the way the allegations are framed. Yep. So 13D, this is one allegation, the band 3 claim for course of treatment between the 20th of June and 19th of July was inappropriate, and that you'd not completed all of the planned treatment that the patient was willing to undergo, as you had identified the need to provide further crowns but had not yet undertaken that treatment. 13E, you failed to inform patient R that the 2 further crowns at UL2 could be provided as part of the same courses of treatment. And F, you inaccurately informed patient R that there had to be a break in her crown treatment because of the NHS patient scheme. So this was all about, as were other allegations, about treatment splitting up courses of treatment. For your note, if you want to understand where this comes from in the judgment of Mr Justice Richie, if you go to page 120, just so that you have it, at paragraph 112 and 113, you'll see that he sets out his understanding of that principle. The nub of it being at 113, it was agreed, expert evidence, that clinicians are not permitted to make more than one NHS claim for a single course of treatment. They're not permitted they should be permitted to split a cot into 2 cots or indeed 3 cots. They're not permitted to charge the NHS twice or 3 times for 1 cot. Herein, when I use the term split cot, what I mean is clinicians splitting a course of treatment. So that's what the allegations in relation to patient R were all about. And what the PCC found is, and you'll see this at C58 and 59, that in relation to patient R, specifically, Ms Williams had already spent a full year doing pure NHS treatment as part of her foundation year. And that included, so they found, making NHS claims for band 2 treatments and band 3 treatments. And so they found, because of that specific experience, that was a sufficient basis for them to find. She would have at least understood that principle. But those findings, in our submission, do not assist the court or the committee one iota with whether she would have picked up requisite knowledge in relation to mixing private and NHS treatment. It was her unchallenged evidence, of course, that she did no private work at all in her foundation year. There was no evidence that she'd ever faced a top-up fee type situation in her foundation year, and there was no finding to that effect. And so insofar as the point might be made, while we rely upon this section, we say it was wrong for the PCC to rely upon findings about knowledge in a different context to support findings about knowledge in relation to top-up fees. Those are all my submissions, unless there's anything I can assist you further.
No, thank you very much. That's most helpful. Anything in reply, Mr. Coulson?
Yes. Can I just deal very shortly, with absolutely no disrespect to Millennium Friends' very eloquent submissions? I just want to make 2 very small points in relation to ground 3. The last point he makes, it is obviously right, in terms of, as it were, the cross-admissibility of the dishonesty finding in relation to the splitting of the treatment and that part of the regulation. Of course, that can only fairly be used against the registrant if the PCC were satisfied on the top-up fee part of the regulations, and then of course it's fair to bring that into play. So I accept his analysis on that. As to the way in which the case was conducted, and again Mr Keller has been very reasonable, one has to bear in mind that we are examining a very, very small part of what was an enormous case, dealing with a lot of separate patients. And I won't read it out, but paragraphs 136 and 137 in the judgment, at page 131 of the core bundle, encapsulates the way in which the judge assessed the cross-examination and the general conduct of this case. And I think there's nothing more perhaps I need to say in relation to that.
Thank you.
just a few points, please, about the thorny...
Back to ground one.
Ground one, yes,
Of
which,
course.
as you know, is our primary submission and concern.
Yes.
Before I do that, can I think Mr Vinnell has answered all of the questions that were raised earlier, but one question my Lord asked as to where in the charging regulations does one find ceramic crowns. I've taken instructions on that, and if you look at the authorities bundle at page 157, Schedule 3, under crowns including any pin or post aids to retention, it is little e where it says crown in porcelain, synthetic resin and any other non-metallic crown. That encompasses ceramic.
Yeah.
Yes, thank you. In our submission, what paragraph 10 does in reality is to set up a binary system. Paragraph 10, which we're all now so horribly familiar with, a contractor may provide privately any part of a course of treatment. So that, read in conjunction with Regulation 2, sets up a distinction, a clear distinction we would submit between NHS and private outside the contract. Now, a course of treatment, it's very important, and forgive me if I'm repeating myself, and the court has this point, but it's very important that we understand that although this case has distilled down into discussion about whether one can split parts in relation to a single tooth, and of course there may be courses of treatment where there is just a single tooth, but one needs to step back and understand that very frequently a course of treatment will encapsulate a whole host of parts or components. And again, I'm going to give you a theoretical one. One course of treatment might include, let's say, 4 crowns, 2 at the front, 2 at the rear, an extraction, root canal treatment, and a filling. Now that's going to be a course of treatment that will be dealt with over a series of different appointments. But that entire course of treatment will attract a single band 3 levy. Now, in our submission, with that in mind, what paragraph 10 is doing is allowing, in that hypothetical, all of those parts or components to be treated on the NHS. But the patient can say, well, in relation to those 2 crowns at the front of my mouth, I would like those to be done privately, and those are then removed, isolated from the course of treatment under the contract. And in our submission, paragraph 10 allows that to be achieved. We're all familiar with other aspects which are removed. Hygienists, for instance, it is another example. Starting from that position, in our submission, what paragraph 10 does not allow for is to do that in relation to a single tooth, to mix NHS and private in a single tooth. And I say that for 2 reasons. First of all, picking up very much, and with thanks to Mr Vinnell, his point, which has to be right, that when you're looking at the single tooth example, the notional porcelain tooth, which attracts the Band 3 levy and the requisite number of UDAs has in fact not been provided on the NHS, because that's been, the ceramic tooth has been provided in a quasi-private way. And so, again, using my learned friend's helpful description, in the single tooth example, what's happening there is you've stripped the NHS from the very thing which allows the Band 3 UDA to be charged. And that is the first reason why we submit that this subdivision in relation to a single item just doesn't work and flies in the face of both the charging regulations and also the UDAs. And moreover, and on this point, a further point which has been contended for is that, well, one, again, with the single item, one could distinguish it between a preparatory part, which is on the NHS, and then the extra part, the thing, the ceramic, which is held privately. But again, if one looks at the charging regulations, there is no charge for preparatory work. There is for examination and assessment, but there is no charge for preparatory work. So if one elides those 2 points, that whatever the intellectual rigour of my lady's argument may be, it's not catered for presently in the charges. So practically speaking, it would be difficult, if not impossible, for a dentist to regulate that. If one elides that fundamental problem with the regulations, coupled with this point that I've sought to make, that you're in fact not providing on the contract that which allows you to charge, if you elide those 2 features together, then in our submission that demonstrates that paragraph 10 works when you take a part out of the course of treatment in its entirety, but it does not work if you seek to do that in respect of a single tooth, a single crown in this instance.
And you have to put it that high because that was repeatedly described as the fundamental tenet of dentistry.
Yes.
Because the words "on the same tooth," which obviously don't appear in the regulations anywhere, was said to be the fundamental tenet.
On the same tooth.
Yes,
Yes.
on the same tooth.
Yes.
So you have to put it that high, otherwise the PCC was wrong.
I do. But I have to, fundamentally, I have to put it that high because I would submit that distinguishes it from the course of treatment example I've given, which paragraph 10 allows for. I hope that is reasonably clear. And of course, added value, this notion of added value, it wouldn't just be a question of cosmetic added value. One can think, for instance, of a patient saying, well, I want the senior dentist, or I want an appointment tomorrow, or I want a double appointment because I'm a very nervous patient. So I think we need to be careful that any notion of added value is not solely confined to aesthetics, but has that wider potential ambit. And the reason why I express myself in the way I do is that these are all examples of how interpreting the regulations in this way means that there are an awful lot of top-up fees, private charges that could be applied to NHS treatment, as I've said, the time, the individual, and so on and so forth. And then one gets into the the floodgates, the unregulated, the uncontrolled aspect of all of this, which I've already submitted upon. And I suppose also stepping back, and I hope this isn't too bold a submission to make, but I can't think of any other publicly funded service. I've been thinking about prescriptions, thinking about legal aid, which we're all very familiar with, that allows for this private top-up fee. And perhaps the reason for that is that top-up fees in this way have the potential to undermine that overriding principle of free dental service, free public service.
I'm not sure about that analogy, because legal aid doesn't allow you to say, well, I'll have the first conference and day 3 of the trial on legal aid, but the other parts I'll have privately.
No, but one can't in legal aid say, well, I'm on legal aid, but I'll pay an extra £500 for that barrister. That's still, anyway, I'm perhaps set a hair running, but yeah, that's the point. So, my lady, I think the fundamental distinction I seek to finally draw your attention to is why we submit that when one looks at the relationship with the charges regulations, why paragraph 10 simply can't be read in the way that is contended for vis-a-vis a single item, but is properly read as removing a part from a course of treatment. My lady, may I, that's all I wish to say, but may I just turn my back just in case those behind me want to make a further point. Thank you. I'm sure it's self-evident to the court, but those behind me, and I've sought to draw some examples, but are fundamentally concerned with inconsistent application of top-up fees and the inevitable deleterious consequences that would have predominantly for patients.
I think all three of us are acutely aware of the importance of this point, over and above the considerable importance to the sorry, I've forgotten her name.
Miss Williams.
Williams. It's just, I take them out of my mind. I'm so used to having to anonymise it to Miss Williams. Any other questions? Any more questions? No, thank you very much. Well, thank you all very much indeed. We're very grateful. This is obviously a very technical point so far as the legal point is concerned, and as I've already indicated, we're very conscious of the greater import of it, but of course the enormous import it is to Ms Williams. So you won't be surprised to hear that we're going to reserve our judgments. I can't tell you precisely when we'll be handing those down, but it will be as soon as that is practicable. They'll be sent out to you in the normal way, in draft, to allow for any typographical, grammatical or minor factual errors, not for an opportunity to re-argue. Can I just remind everyone about the new terms of the embargo at the top of the draft judgments, and we will require the lists to be sent in the normal way as to who will have access to the draft judgments. Particularly important, always important, but particularly important in a case like this, where it's critical that the draft judgments don't leach out before they've been perfected and handed down. Hope you would be able to deal with all other matters in writing. If there's any ancillary matters, we'll deal with them in writing and look to an agreed order at the end of the day. Thank you all very much, and can I thank